So the best part is penalties are up to 250 crore rupees. And when I say up to, the range is between 50 crores to 250 crores. If the penalties are not high, no one is bothered to comply with those laws.
Yeah.
For that relief factor, we have this DPDP Act. They have started to recognize what kind of law is this, why is it important, and more importantly, in the bigger picture, I see tomorrow you can't go to the court and say, sorry, the data principal didn't answer my notice. No, it's your duty. And if they're not answering your notice, then you can't take that data no matter what happens. This just simply shows that bringing a law is one thing, implementation is another. That's why this law specifically says that whenever and whatever data you are taking, you have to simplify and explain the purpose behind that data.
In that case, do you mean that when you apply it, it means that we tell about each and every field and how it applies to the purpose? Or like in general, you are creating customer profile and that will help us with the overall purpose of the application or the product?
Like for example, I always give this example of colleges, right? Let's say the student has passed out and it's been more than 15 years. That data is still there. No one is bothered.
Yeah.
What should be, what kind of data is there, why it should be there, no one asks you the question. And tomorrow when a data breach attack takes place on these servers of the college, the data is gone.
But for most of the organizations that we have here, can definitely tackle this within this timeline.
Data is not a joke. Data is definitely not a joke, because when I say you, I'm talking about data fiduciaries, data principals. If these two entities will take data as a joke, no one in the whole world would trust our country with respect to data.
Welcome to Breakpoint. I'm your host, Neelu, and here we are decoding the bleeding edge of cybersecurity. We are here to challenge assumptions, explore breakthrough defense, and learn from some of the most innovative minds in the field. Enjoy, folks. Hi, and welcome everyone to this episode of Breakpoint. The topic for today is DPDP Act and compliance and a bunch of challenges that come with it. To discuss this today, we are here to learn from the experience of our guest, Saakshar Duggal. He is an AI law expert and he also trains multiple corporates on cyber laws and cyber hygiene. Welcome to Breakpoint, Saakshar.
Thank you so much, Neelu. It's indeed a pleasure, and I'm looking forward for this discussion.
Cool. So DPDP Act, I think there have been tons of data security acts and regulations around the world, and we have been seeing the degree of complexity from basic to complex. So we have every variety. And recently, there was the DPDP, the Data Protection, the Data Privacy Act that Indian government came up with, and the regulation. So while it's a good move, there are some challenges there, which we would love to learn from your experience around in that area. So first of all, when we talk about DPDP as an act, how would you maybe briefly share what's in scope of this? Like, how do we first as a company start thinking or looking at it?
See, as you said correctly, there have been a couple of acts which have been there. So what's so special about the DPDP Act? Well, two major things. Number one, the timing of it. I mean, right now, India is the most populous nation in the whole world, and it's a growing economy. Everyone is looking at India. The startup wave has suddenly increased in India, the entrepreneurship wave, as I said, as well as the AI boom is there. So with all these factors in place, different companies are investing in India. And then big companies, countries are investing in India. So obviously, there is an exchange of data. There is a high stakes situation where data of different companies, different countries is there with India. So India has to come up with something. So I would not say a guarantee, but a law, some a kind of a thing which gives reliefs to the countries and the companies who are giving their data. And for that relief factor, we have this DPDP Act. And if you closely look at the DPDP Act, it's more about the scrutiny on data fiduciaries and data processors, right? And a lot of people, they have this debate, but as a matter of fact, we have to understand that the harsh reality is that data fiduciaries, data processors, and data principals, every party, no one is bothered about data. Data principals are not bothered about their own data. Data fiduciaries, for them, they just take data and they market out of it, or sometimes they just keep it on clouds as well, all those Amazon clouds and stuff. So at the end of the day, one has to realize the real importance of data. That's why DPDP has come up. So this was factor number one. Factor number two, which with with which DPDP has got famous among the corporate space is the penalty sector. See,
Hmm.
the fact of the matter is that no matter what kind of law is there, if the penalties are not high, no one is bothered to comply
To
with those
comply with it.
laws.
Yeah, yeah.
And in this case, DPDP, so the best part is penalties are up to 250 crore rupees. And when I say up to, the range is between 50 crores to 250 crores. Even 50 crore penalty is a huge penalty for any corporate, for any organization. And since the penalties are at large, that's why people and companies they have started to recognize what kind of law is this, why is it important, and more importantly, in the bigger picture, I see this law creating more sensitization amongst the public with regards to the importance of data.
Thanks for sharing that. But I think before we move further, I mean, I'm sure we will look into and dive deeper into the whole thing and, why there's so much penalty and what needs to be done. Can you double click a little bit on the data principles and the fiduciary? What is the role they play in the entire chain as per the act?
Sure. So with every law, there are different main characters, or I would say main parties to every law, right? In this case, we have four main parties. Number one is the data principle. In simple terms, data principle is us, the person, the customer whose
Whose
data will
data
be
is,
stored
yeah.
and whose data will be processed, right? So you can say it can be you, it can be me. If I today I'm going and using someone's services, some company's services, I'm giving my data to them. And when I say data, it's not general data, it's only personal data. A lot of people have this confusion that the DPDP Act covers all sorts of data. No, the word simply says digital personal data protection.
Yeah.
It's all about your personal data. That was data principle. Coming to data fiduciary. Now, this is the second party, which is the company who will be taking your data, who will be storing your data, who will be deciding how the processing will be done. So, the decision making party is the data fiduciary. What all things will be done with your data. And in a simple example, this will be the company. For example, if you are, let's say you're a customer of Amazon. So Amazon here becomes the data fiduciary. It is storing your data, receiving your data, and it will decide how your data will be processed. Number three is data processor. Now, data processor, somewhere, see, you have to understand data fiduciaries here and under which is data processor. Data processor decides how the data will be processed and it will be telling the data processor to process it in that regard. So, in terms of small companies, the company itself is a data fiduciary and a data processor. But in terms of big companies, they outsource this service to other companies. So, processing of data is done by a third party, right? And number four, number four, which is, I would say, the main party or the most interesting party in this law, is the Data Protection Board. There are no courts. There is, yes, there are appellate tribunals afterwards, but initially, the compliance, the adherence of this law will only be taken care by the Data Protection Board. This obviously it's to the government. People would be there, and it is in an online space. There is no, like we have physical courts. There is no physical Data Protection Board. It will be there in an online space, but whenever a grievance is raised by a data principal, the data principal will go to the data protection board, and the data protection board will see whether this grievance has some merit in it or not. If yes, then obviously data fiduciaries will be taken into custody, will be asked different questions, auditing will be done in order to understand whether they have complied with the law or not.
Okay, great. Thanks. Thanks. That tells a lot about the way and manner in which it is structured overall, as we'll discuss. And I was just thinking, on a lighter note, that we are so used to physical courts, so yeah, we'll miss that. But coming back to the act itself, well, like I was talking to you about the earlier other regulations that have been in place. Can you slightly tell us how, while many of us in India are also implementing these regulations, for example, GDPR, right? It's slightly more complex and there are many clauses in there. What is the major difference that you would say is between such data privacy laws that are there outside and the DPDP Act itself?
There are two things. A lot of people ask me whether this act is good or bad. And my answer to this is in life, there is nothing black or white, it's always gray. So when we compare this law with GDPR, you can't compare it because of two simple reasons. Number one, GDPR, when it came in, right, it's, a lot of people, they had their, they were suspicious, they were not sure how will this law work, this and that. But at the end of the day, after 7 years, it is comprehensively working. And that's great. And I completely admire GDPR because it is a foolproof law. I mean,
Mm-hmm.
whenever there is a provision, it has its own, there are different provisions and sections which amplify and simplify every single thing. But in DPDP's case, the only drawback is that it's just a draft bill which is out. So you can't expect that it will be 100% great. No, it's not.
Mm-hmm.
There are a couple of gray areas in DPTP Act as well. Though we have been given this surety by the government that the final product, the final act which will be out there will be addressing to these gray areas. But if you ask me, I don't think every gray area will be addressed right now. It will take some
Hmm.
time. But the good part is that we needed this. We needed a law specifically in India to understand what is the value of our data. And as you said correctly, see, we are habitual beings. We don't value our data, we dump our data, we overshare our data. And the major thing is we think that we are no celebrities, right? So why should we care if our data gets leaked? But let's face it, that data gets leaked and it becomes a potential for a criminal, for a cyber criminal to attack you, whether it's your phone number, your email ID, your Aadhaar card, or anything. So as a matter of fact, this the main objective and the first objective of this law is to create awareness and importance of data. And
Hmm.
obviously, gradually, when different cases would come, and this happens with every other law, when different cases come, new contentions are there, new situations are there, and new amendments are done with respect to the law. So I'm also expecting that DPDP will go through a lot of amendments and different changes throughout this journey.
Yeah, like you rightly mentioned, the first step was very, very necessary. I think all the regulations they mature over time, and then clauses will be added, removed, changed, updated depending on, especially because a fine is also involved. So it makes sense to have more clarity specifically in some areas and the way data is handled. And speaking of handling data in a specific way, one of the tricky areas, I would say, not challenging but very tricky, is the consent management bit, which I wanted to actually talk to you about and what your experience has been in this space. It can be a big challenge sometimes when a company has never done it before and it already has a series of products and applications where data is being taken from the customers or the end customers. When they are trying to actually sit down and now implement consent management, and we are talking of getting not just consent, like specific consent, informed consent, maintaining this information and being able to track it over time, and then also when the consent is withdrawn, this is one of the clauses, as I understand, the organization should also be able to get rid of that data, right? So what do you actually recommend in your experience for companies to do in consent management?
So you're absolutely correct. Most of the companies, they are not used to all this, specifically here. And I don't blame them honestly, because as human beings, we are careless by nature. So in Europe, I always give this example. It's not just about Indians. In Europe also, before GDPR, no one was bothered about their data. It's only after GDPR, after these years, people have, they've got acquainted with this concept. They have now become matured with respect to their rights in the data ecosystem. But I'll give you a real life example. So there is one of our clients. He is obviously this corporate, and so the good part is that right now only 10 to 15% companies are there which are taking DPTP seriously. The other 80-85%
Okay.
companies, they have this attitude that okay, we'll see,
जब आएगा
we'll
तब
see,
देखा जाएगा
exactly.
types,
जब
yeah.
आएगा तब देखा जाएगा. When the bridge would come, then we'll see how to cross it, right? So, but the good part is those 10 to 15% companies, they understand the huge stakes behind this, and they are actively working upon it. So this corporate, they came in and they have a name. So obviously their brand reputation is at stake. That is
Mm-hmm.
why they are serious as well.
Mm-hmm.
So the first part was consent management. So in this act, there is a specific format in which you have to take the consent. There is a proper notice which you have to give to your data principals in a proper format. It should be transparent, it should be clear, and consent should not be, it should be free. There should be no pressure on the data principal, and you have to be very much transparent with respect to your language as well. So the interesting part in this case was that, and right now this process is going. So they have sent notices on mail to their existing customers that explaining everything. That till now
Okay.
you were taking our services, we had your data, but with regards to this law, with regards to this section, we are sending this, we are intimating you. that please, give us your consent, a proper consent, no implied consents at all, right? Now, the interesting part is, first of all, as a matter of practice, they are feeling a little odd because they are not used to it. So they are not used to sending notices, asking for
Neither the
consent.
customers. Yeah.
Exactly. And number two are the customers. A lot of customers, they are seeing this as a spam message. So they are not even replying to it. That's the interesting part. And
Smart.
a lot of customers have, called them and told them, what is the spam thing that you're sending us? What kind of consent do you need? This and that. This just simply shows that bringing a law is one thing, implementation is another. So this company right now is taking charge. It is explaining whatever customers who are not replying to them, they're sending another mail explaining the logic behind this notice. Where did it come from? This is not a spam, this and that. The whole clarification process is going on. So what I'm trying to say here is, this is not just about my client, but this will happen to most of the companies out there. Data principals would not be bothered, but at the end of the day, the harsh reality is that there are severe penalties on the data fiduciary. Tomorrow you can't go to the court and say, sorry, the data principal didn't answer my notice. No, it's your duty. And if they're not answering your notice, then you can't take that data no matter what happens. So this part is this confusing part, and this the part where they have to convince the data principals. That would happen, but you can't skip the aspects of law. This client of mine, he was so frustrated after one point. He was like, "Can't I skip some steps, and I can just get on my work?" I was like, "No, you can't, because the beauty about this law is, even if, let's say, you have 10 steps to do, if you are just doing nine, and if you have missed one, whether it's out of negligence, whether it's out of you know out of any other thing, you will be scrutinized. You can't say, out of 50 crores, I have done nine things, so please give me a penalty of 1 crore only. No, 50 crores or 250 crores will be given, even if there is one mistake that the data protection board will find in your conduct, in your process, and in your strategy.
So you brought up an interesting thing, and I'm always and often working on products. So the consent that we're taking, the medium of consent, is it specified? Because sending consent mails seems a little actually out of place. So if, in a way, I would not blame the customers that they are, a little scary because of the kind of mails that people keep getting, right? In terms of spam, generally you would get something like a pop-up in the application itself, or something, a section in the application where they clearly call this out and get your consent explicitly. So are there formats defined as of today for how the consent needs to be taken?
How the consent is defined, and obviously it should be free and everything is there. Those specifications are there, but regarding format, there is no such clarity. So
Okay.
there are different mediums through which different companies. So a couple of our clients, like this client is using mail. The other client, so they are first calling the customers. They are explaining that they will receive this mail. So please acknowledge that. This is
Mm.
category number two. Category number three is sending normal messages with their official numbers. It's not a spam. You're getting a normal message, and sometimes on WhatsApp as well. These days, obviously, these companies have access to your WhatsApp. So on WhatsApp also, they are sending, clarifying this is not a spam. This is part of the routine, part of this law, which is there. And the best part that I can say to the data fiduciaries is that whenever you are explaining your customer about this, please tell them that they can't give you the service till the time you're not consenting to their data. For
Yeah.
example, if today I'm a data fiduciary and you are asking, you have come to me for a certain service, but if you will not consent to me that, yes, Mr. Data Fiduciary, you can take my data, I will not be able to proceed with giving you the services. So therefore, I've stopped, and it impacts both the data fiduciary and the data principal. Once the data principal understands that, okay, why is this data being taken? It's like, without the consent, they can't move forward. That's where I've seen right now that data principals are corporate. When they understand the logic. So the only challenge here is making them understand the fundamentals. Why is this notice out there?
Yeah, yeah, I think that's a very, very good approach that you've suggested for, approaching at least the existing clients and looking at it. But I was just thinking maybe it'll be simpler for many of the organizations who have either not thought about it or have already started thinking about it to have this inbuilt in the applications when they start off the new ones. So there are many new applications being built. Already consider it if you are building or you are specifically in scope for DPDP in any way.
Startups, I know a lot of startups are doing this practice now,
Yeah,
because
that makes
for the new
sense.
customer, and specifically for a startup, the stakes are quite high. They need to gain that the trust of their respective customers. So they are
Yeah.
automatically and by default, they are not doing this practice.
Yeah, yeah. Okay, talking of startups and in general, so this is something that I was also involved in, like I think some time back. It was a few years ago when this movement of sorts started. That's also one of the clauses in DPDP which I wanted to discuss, and is close to me in a way because I really believe that is possible. So that is of data minimization and purpose limitation. So purpose limitation seems straightforward, but I'm talking about data minimization largely because you can get rid of a lot of unnecessary data that way, and then you don't have to take consent on that data or even process that data for that matter. So with respect to data minimization and the collection of data, like first of all, how do companies approach this problem? Because and I'll tell you the approach that has traditionally been there because we've been working with developers for a very long time. They're like, ye bhi le lo, wo bhi le lo. You just create an object that has. So if it's for example, every workflow will have sort of objects that they deal with, and an object actually collects all the data around all of this, specifically customer data, because you have a profile, take everything in the profile because you may need it in future. So there is a lot of implied understanding on taking a lot of data about the customer. How do they approach preventing that in a way?
Well, as you said correctly, it's the practice has been there, and I think it has been abused as well. That is why our data is getting abused because so-called implied consent is there, and neither the data principals are bothered, neither data fiduciaries are bothered. That's why this law specifically says that whenever and whatever data you are taking, you have to simplify and explain the purpose behind that data, the purpose, the duration as well, and it should be justified. You like, for example, I always give this example of colleges, right? So college has its. There was a study which said that students who have passed out from college, from an average, let's say Indian college, let's say the student has passed out and it's been more than 15 years, that data is still there. No one is
Yeah.
bothered what should be, what kind of data is there, why it should be there. No one asked you the question. And tomorrow when a data breach attack takes place on these servers of the college, your data is gone. It should have never been there. So because of all these things, this law simply says whatever data you're taking, first of all, define the purpose, exact purpose. It should not be a vague purpose. Specify the purpose, why you're taking this data, specify the duration, and it should be justified. So when a college says that I'm taking your data for 10 years, you need to justify why 10 years. But if it's saying it's only for 3 years till the time you're here, once you have, you have passed out, we'll delete your data. That's fine. Same goes for companies. A lot of companies, they say, so there was this interesting point. One of our clients, when I was discussing the same point with my client, so he said that, sir, how about we'll do one thing? He tried to tweak the law. He said that, how about, I can say that my company generally takes a lot of surveys. So I'm taking this data for the survey. So that's justified.
So
I said, no, sorry. No,
this is
sorry.
like a
You can't just, exactly, you
one
can't
size
tweak.
fits all approach.
Exactly. So I said you can't tweak this law like that. You have to specify what kind of survey is this. Does this survey, there are a couple of things. Do you really need to conduct this survey? Do you really need that data for that survey? And if it's not justified, even if you are so convincing enough that, okay, I need this survey, I need this data, no. If the data protection board is saying that it's not justified at all. So therefore, you have to be transparent. See, at the end of the day, this law is only encouraging transparency. Right now, there is no transparency. With this law coming in, people will be accountable, people would be aware, and more importantly, there will be a transparent nature between the customer and the company.
I want to actually just quickly talk about some nuances here. I think it will apply differently to different applications and different businesses. But for example, if most of the times your personal data oftentimes is collected in your profile, and everybody's asking for, so create a profile so that there's a customer profile, and then customer profile applies to different aspects of the application depending on what they're doing. For example, if address is being collected and you do not have a shipping service in your application, right? So if you had a shipping service, you can still say, right, that you need the address. But then in that case, do you mean that when you apply it, it means that we tell about each and every field and how it applies to the purpose, or like in general, you are creating customer profile and that will help us with the overall purpose of the application or the product?
See, in customer profile, if I'm asking for your name, email ID, it's still fine. I can just, conceptualize all these in in one bracket, right? And I'm taking your data because of XYZ. But other specifications, for example, I'll give you a practical example. Okay. If today a car service company, Ola, Uber types, right? And initially this used to happen. And they gave, when they operated in India, initially, they used to ask for your gallery as well, gallery permissions, voice.
Hmm.
See, they need location, they need phone. I can understand that. But what about camera? What about your gallery? What about your microphone? That's not allowed and that's not justified, right?
Yeah.
So similarly, and this kind of practice happens when you are, let's say, you are taking you reach out to a data fiduciary, you're taking the services, and in that create your profile form, and in the, a lot of things are added which are unnecessary. So whatever data, extra data you want from your data principal, you have to mention and justify why am I taking your data, till what duration. I feel duration is a tricky point. Why? Because initially, if you ask me, companies would be transparent with the purpose of the data, but
Mm-hmm.
they would miss out on the duration because duration is specific. Purpose, I can say that okay, the purpose is to give you services. That's still fine. But duration is in numbers, 2 years, 1 year, three
Mm.
months. That calculation, whatever calculation you are coming up, you need a proper logic behind it. So while creating a profile, practically companies would be clubbing it. And clubbing is not bad till the time you're justifying and you're being transparent why you are taking this data and till what duration you will be taking this data.
Talking of duration, actually, this is a very important aspect, and I was going through it. I didn't see anything specifically called out, unlike other regulations where we have a duration specified and called out. Ki, okay, these many years should be the data retention. Here, it's I think not called out. Please correct me if I'm wrong. And data must be erased after this duration is done, or if the consent is withdrawn in both the cases. But I was just thinking to myself, because there is no specific number of years, and I understand in some businesses it might apply differently, so number of years will be different. How should companies then actually define the retention years for which will apply to, for example, all the customers which are there? What is the right way of doing that? Because you can often tend to, if you keep a lot of buffer, it will not be great for the customers, because if there is an attack, if there is a breach, like you were mentioning, then all that data all those years ago would be there with the company. And if it is too less, it may not serve the business purpose. So what's your how would you define, when they're doing implementation, actually think about the data retention?
Now, this is a confusing point. That's true because the law doesn't mention a specific timeline, a specific duration. That's one. You talked about consent or erasing the data. The law here creates flexibility. It simply says that when the data principal wants and has communicated that I want my data to be erased, no questions asked. The data fiduciary can't ask why, what happened. It is only based upon the free will of the data principal. So whenever, if today, let's say a simple example, if today I've subscribed to your services, after 4 days, out of no reason, I just contact you and say, please delete my data. You have to delete the data. You will not say what happened. Did my company do? Are you not liking my services? This and that. No, a no means a simple no. That's one part. Now, coming to what should be done. Well, if you ask me right now, we have, whenever I'm seeing these kind of cases, there is confusion on this part because every industry has their certain, there are different protocols. It's a different thing which they are producing. Different industries are there, different companies are there. Every company's working style is different, commitment is different, right? So, if you ask me, the law, this is the gray area that I'm talking about. These are the couple of gray points. So the law
Mm-hmm.
should specify at least a proper standard, or you can say the max period or a minimum period, a range. At least a range can be provided so that some kind of clarity is there. No one will abuse this because the law simply says reasonable. Now, reasonable timeline is a subjective word. For
Yeah,
me, 1 year is
very
reasonable. For
relative.
you, 10 years is reasonable, right? So here the abuse of law can be there, and that's where I'm believing that whenever this law is out there, the government is also, given this assurity that these gray areas will be touched upon.
So talking of which, in any of your experiences, have you seen in a scenario where this retention period has not been defined and they're thinking of DPDP currently, but at the same time there may be other regulations applicable where there is a retention period defined, or there are multiple applicable compliances where they are, for example, for financial companies, you will need to keep the data for a certain number, 7 years, or 10 years, and then in some of the cases it may be more or less. And then there is this DPDP Act where we have a different retention as per, for example, as per our purpose, or things like that. And how does it also clash with consent? Because now if there is financial data involved and you're supposed to retain the data for a few number of years, then how does it apply? Because in that case, as per the withdrawing of consent, you're supposed to delete the data, but as per another regulation, you're not supposed to delete the data. So how does it all work?
There are a couple of things. It's you have to see this layer by layer. And
Okay.
our client is also in the financial sector. So he's in the
Okay.
financial sector and he's doing the same thing because this is the only solution they have. Because at the end of the day, see, if some mishappening takes place, the data protection board will ask you. In that regard, if you're following the industry standards, some guidelines in your sector, you're still safe. You're justifying that these 7 years I'm using is not out of my own will. It's
Okay.
because the industry standard is there. But coming to your second question, what happens if the data is withdrawn? See, the act says a simple statement, which is that whenever we will talk about personal data, DPDP will supersede every other law or every other, you can say policy regulations. So
Oh,
when we
okay.
talk about personal data, DPDP is at the top. And this, another question which a lot of people have a doubt: which one is, which one supersedes, IT Act or the DPDP? And the answer is simple: IT Act supersedes every time. It's only the personal data. The personal data sector is where DPDP supersedes it. Otherwise, IT Act is the boss. Coming back, yes, there will be couple of confusions, couple of problems, and that's why, as I said in the previous answer, if the law specifies a certain standard, a certain duration, then this confusion eliminates. Because right now, see, you asked this question and I'm answering it on this podcast, but a lot of people, they have the same confusion: what to
Hmm.
do, what not to do. That's why the clear the the if the law specifies this specific timeline, the better it will be, because it sets a certain standard. Because in different industries, different protocols are there, different timelines are there, and in different companies will follow different timelines, then the law will not be able to streamline everything properly.
Yeah. Yeah, and I think it can lead to a lot of confusion, conflict in cases of when they actually go to the data protection board for some of these conflicts for companies where there are different regulations applicable. This might actually get very, very confusing and complex unless it has been clarified upfront in the law or in the regulation, actually. Okay, so I was also trying to understand the breach reporting part a bit. So many regulations have clarified, in general, what should be your kind of breach reporting you should have, what information you need to provide, what are the timelines within which you have to provide this information. And this is slightly stricter in other regulations, is what I felt. Please, correct me if I'm wrong. I think in the case of DPDP, or maybe because it's in a draft stage, we've been a little more lenient with how and how much reporting can be done and what are the timelines and things like that. How should organizations actually prepare for reporting such issues, like in terms of having the right kind of template, so as soon as there are breaches or there is a breach, they reach out to specific contacts, specific parties, maintain those contacts, and have the right kind of information floated out? Or is there more to it with respect to the breach reporting part?
I think it's more about the protocols and more about the basic practices that every company follows. See, right now, unfortunately, reporting compliances has just become a tick box kind of an exercise. They're not part of your daily practices, daily, I would say, processes of a company, right? It's not part of the culture. That's the right word. It's not part of the
Hmm.
culture. And with this act, the major thing. So I've met a couple of people who were in the drafting committee of this respective act, and I asked them the same question. So their answer was very simple. It was that, see, we don't want to overwhelm people straight away. With this draft being out, already companies were in a panic mode. They were against this. How would this happen? How can you put 250 crores in this and that? So seeing
Fineness, I
that,
think.
exactly, seeing that, and it's kind of a, you're challenging the mindset of the whole nation. No one is ready for managing data properly, both the parties. So you can't straight away put up this comprehensive law and people would get overwhelmed, companies would get overwhelmed, and as a matter of fact, they will obviously goof up. With
Hmm.
regards to that, it's more like a step-by-step process where yes, you know, on a surface level, the reporting mechanism is given that okay, you will go, you will report to this and that. Basic rules are given. But regards to the specifications, I personally believe new amendments will be a game changer, and this is the right approach. A lot of people say that it's a vague law. Yes, it's a vague law in a lot of areas, but more importantly, see the brighter side that if it would have been so comprehensive, I can bet on that. I can vouch on that 90% of companies would have been so overwhelmed in the process that they would have definitely not been able to implement this properly. At least right now it's at stage one, so you can implement it easily. And yes, the government has also given some time. It's not that today the law has come up, you only have 1 month. You have a period more than a year.
Hmm.
There you can actually see your processes, make data protection and data auditing part of your culture. Once that happens, then I'm 100% sure new things slowly and gradually will be introduced in this regard.
Yeah, very rightly put. Actually, we have seen different regulations being implemented, and then I remember, although I wasn't deeply working on GDPR, I've seen a lot of my friends who've been trying to implement GDPR. When that came in, and for organizations which had a lot of things automated, centralized, and taken care of, were actually rushing, working day in and day out for thousands of, looking at thousands of documents, data stores that they have within their organization. Entire enterprise was turned upside down. And I think it took a long time to make sure that things are in place and then they are compliant with something like GDPR. And in India, we are not prepared yet, although we are helping many other MNCs, many other organizations who have these applicable compliances for ourselves. I think it also takes a mindset, like you rightly pointed out, but also investment, because other companies are investing in these audits that you're talking about, in making sure that all of this is automated, tracked, maintained, and managed well, so that you can actually implement these laws and regulations well. So this needs to be taken step by step and gradually. So talking of which, in your experience, I wanted to know, what does good look like in this case? So this is of course not highly comprehensive, but there are a few things which are already defined in case of DPDP. Have you had any successful implementations that you have seen or done for clients, where what would good look like for you in terms of they being in the right path, so that other companies or other security teams that are watching this podcast can actually understand that they are in the right direction? What should be the approach, what should be the mindset while they're building systems? How do they handle this data?
See, the biggest mindset problem that I've seen with almost all the companies is that they are focusing upon the penalty aspect of this law. Only because there is a huge
Thank
penalty,
God for that.
that is where we'll make the compliances. But some companies who are smart, who will grow, is not looking in this regard. Their perspective is different. They are looking DPDP as a true mechanism of creating more trust with their customers. What I
Hmm.
mean by this is that if you'll comply with the DPDP Act, if you'll have these kind of processes in your company's culture, so this would help you to gain more trust from your customer. Let's face it, if today I'm a customer of one company and they are securely they are respecting my data, they are keeping it transparent, they are informing us if certain thing happens, reporting us on time. All of these things just increases the trust of the customer. Because in today's data economy, yes, goodwill is there, face value is there, but if you can't keep your customers' data safe, if you will abuse that data, then I'm sorry to say, somewhere or the other, your customer won't trust you. So, number one is change of mindset. Don't look at the penalties, but
Hmm.
look at more as an opportunity. Number two, the simple processes, the simple aspects the DPTP Act says, the practices. They should be part of your culture. I know it's not easy. It will take time. And that is why the government has given you the time that please start now. It won't happen in 2 or 3 months, but it can definitely happen in a year. When your team, when every member of your team gets used to this culture. That is number two. Number three is, wherever we are talking about the gray areas, don't skip and don't try to manipulate the gray areas. The example that I told you, the guy was saying we'll ask for survey data and this and that. No, don't try to be smart, because you have to understand one thing. It's not about you versus the data principle. It's you versus the government. Why am I saying that? Because whatever data that you will, whatever not data, but whatever penalties that are there, 250 crore rupees, a data principal won't be getting these 250 crore rupees. All of this would be going in the provident fund of the government, India. So technically, you're messing with authority. You're not messing with one person. And a lot of people have, they debate on this aspect. Why is this? The simple answer to this is that, unfortunately, a lot of major data fiduciaries, they think that it's just a data principle, right? Court cases will take time and we can then take care of it. They abuse their power. That is why it's not the data principle versus the data fiduciary. It's data fiduciary versus the government. Once you're against the government, you'll not try to mess around. And the government, with this law, they have been very much crystal clear that this law is not to be messed around with. You need to take it seriously, because now, the juncture at which India is standing upon, data is not a joke. Data is definitely not a joke, because when I say you, I'm talking about data fiduciaries, data principles. If these two entities will take data as a joke, no one in the whole world would trust our country with respect to data. If data is a joke, why would someone trust their data, their essential credentials with you? That is why you have to understand this third aspect. And number four, be a little flexible. Why am I saying flexible? Because let's say you have complied with the DPDP Act, different changes would be coming up, different challenges would be coming up. So you should have that scope of flexibility, that okay, today I'm fine, but tomorrow if something changes, some new thing comes up, I'm flexible of changing my dynamics here and there. I'm only tweaking. When I'm saying change, it's not a massive change. It's just a small tweaking, small addition, subtraction to your process.
Yeah, thanks for detailing that a lot. I think the mindset change is definitely something that's at the heart of all of this. And I believe that, yes, they need to be doing this in a more sustainable fashion. Looking at shortcuts here and there will and may work for now, but then in the longer term, they should be looking at it more strategically as a part of their, not just their data strategy, the data security strategy, but also the aspect where you are tying entire data security to business value outcomes, which you were talking about, right? So that makes it way more sustainable. That makes it way more attractive for example, your CEO, CTO, who you talking to as a security team as well, right? So that conversation will be much easier, and it will actually also benefit the company in the long run in a lot of ways. I was also thinking, while you're talking about, is while building the mindset is at the heart of it, building the systems will also help in future, where you can automate a lot of these things, manage a lot of these things, and track it better, so that even if there are clauses being added, there are certain amendments, you can take off it very easily. So this period that the government has given can be utilized pretty well, for at least for the small to mid-sized organizations. I know large size organization enterprises have a lot of applications, so they will have to work on it differently and at scale. But for most of the organizations that we have here, can definitely tackle this within this timeline.
That's
So,
true. And the most interesting part is, I would just like to add upon, is that don't completely rely on automation. Today, I'm seeing a lot of corporates, seeing a lot of OEM companies. They are bringing up their own softwares, and yes, they are great for helping. But just blindly trusting on these automations and being careless, not having that attitude of doing the compliance, won't serve you. Because yes, these automations are great, but at the heart of all the things, it's your own mindset, the company's culture, and how you actually respect that data that speaks true volumes.
yeah, the mindset is at the heart of it. I think that will enable a lot of these other things where you can, strategically tackle this in future. But yeah, thanks for sharing all of this today, Sakshar. How did you like being on the podcast?
Well, it was a pleasure, and the best part is that I personally was satisfied that I was able to bust a couple of myths and was able to bring up certain practical points which are actually happening right now.
in this space. Yeah, yeah, definitely. It was also eye-opening for me, learning from your experiences. So thanks a lot. Thanks a lot for joining us today in this episode.
It's a pleasure. Thank you so much.
Thanks everyone for joining us today in this episode. We'll see you all in the next episode. Until then, bye bye.